Welcome to this free immigration help channel. Today is August 14, 2023, and we are getting into the volume 149 of me answering some of your immigration related questions. So, before beginning this video, I am going to mention, as I always mention, I am not an immigration attorney. This is not legal advice. All the information provided in these videos are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question. Comment from Pierre Dumi 9995. What is your current immigration status when you are renewing TPS? So TPS is a temporary protected status. So if you are renewing your temporary protected status, you are under the TPS. So what you can do is you can just put TPS, and I would recommend, if it's one of those blank fields, which is most likely what you're referring to, putting the TPS and also the country where you have the TPS from, so that it is nice and clear for the immigration officer that is reviewing your application. So pretty straightforward. Let me pause the answer here and we're going to move on to the next question. Comment from Disa Patel. Hello, recently I became a US citizen. Congratulations. And I sent my naturalization certificate to the USCIS service center assigned to me for the I-130 form to change my file to an immediate relative category. Awesome. How can I know USCIS changed my file to an immediate relative category? They inform me or they don't inform me. If the case status is case being actively reviewed by USCIS, how long does it take to go to the next step? Thanks. Disa, thank you very much for your question. That's a great question. So your case is definitely still with USCIS because we know that it is being actively reviewed by USCIS. So to answer your question, whenever it comes to the status change, you will definitely do get the notification if your status is changed by USCIS. If there is a lot of time left for USCIS to review your case, and the only way we can tell that is by checking USCIS processing times. That's really where, and I will put the link in the comment so that you can find it, but it is all on the official government website, which is US Citizenship and Immigration Services, uscis.gov. So we're gonna go to case status online, and you already checked that here because you know that it's being actively reviewed. If we're gonna go to the processing times, here we're gonna select the I-130 because that's your status. So if you are switching to an immediate relative, right now it's not immediate relative, so most likely you're petitioning for a spouse, but obviously you can put your own in there. So let's see, permanent resident for now. Let's do that first, because if they haven't updated your case yet, then they still have you as a permanent resident. And then depending on which service center your application is being processed at, you will select whichever one is corresponding. You can find the correct one on the receipt that you received, the initial receipt from USCIS. So I'm gonna select all field offices for now, and looks like we're getting error. There you go. So 37 months for a permanent resident, but let's check this for a US citizen and see what's gonna show us. So 37 for permanent resident, and then 28, so 9 months less processing time with USCIS for US citizen, which is definitely much better. So if they have enough time to update your case and process it as a US citizen rather than permanent resident, then definitely beneficial. But regardless, the best part about your case, about your situation, is that you are able to update it before your case was sent to the NVC, and that's where it really makes the difference. Because here it's 9 months. Yes, of course, it's 9 months, and it makes the difference. But compared to being processed as F2A with NVC, compared to being processed as an immediate relative, that is a huge difference, because now you're not dealing with a backlog at all, and it saves you a lot of time. So regardless whether there is enough time for USCIS to update your case, to immediate relative category or not, to you being a US citizen, yes, of course it will make a difference, but not as much. But by the time it is sent to the NVC, it's going to be updated regardless to immediate relative category. now since you are a US citizen. So yes, hopefully that answers your question. Basically, to answer each of your question, how can I know US changed my file to an immediate relative category? You will definitely get a notification if there is enough time for them to update it. Because if you're close to your case being approved, if the timeline, you will have to check the processing time once again. And actually, let me paste it in my comment so that you have that. If it is really close to completion, then most likely, there won't be enough time and they will just approve it, and then they will send it already as an immediate relative case to the NVC. But if there is still more time for pending in, waiting, that's not the link. Let me, can't do two things at the same time, talking and typing. There we go. And then, yes, they will inform you again if they have enough time before the case completion at the USCIS. They will inform you. They will send you the, a notice that it was updated. And then if the case status is case being, how long does it take to go to the next step? And then again, for that, to answer that, you will have to click the link and check, depending on which service center where your case is at, you will be able to tell. All right, let's move on to the next question, comment from Osigvera Rachel. Oh wait, Osigvera Rachel, 1021. Probably completely mispronouncing this. Sorry about that. What about spouse of US citizen? Do we have to deal with the backlog? No, you don't have to deal with the backlog as a spouse of a US citizen because you are in immediate relative category, which is what Disa Patel is updating the case to now. You are still waiting. There is still time that you will be dealing with, for USCIS to review the case. Then once they approve it, they send it to NVC. Then NVC reviews the case. You become documentarily qualified. Then you wait for the interview to be scheduled. So there is still time involved, and it can take around a year and a half, 2 years. It can take, but you are not dealing with the backlog, and of course that is a huge plus. Okay, let me post the answer here, and let's move on to the next one from Nola Wee Hancock 4426 or Hancock. Nola Wee Hancock. Wow, I can't read the names today. So sorry about that, YouTube. I'm gonna blame this on YouTube because instead of showing me the names, they now show me the handles. I don't know why they did it, but that's how it is. F4 visa, rest of the world, priority date April 06, 2007, documentarily qualified December 2022, awesome. Interview not being scheduled. Been 4 months since it became current. How long will it take? How long will it take till they give us an interview date? Nola, thank you very much for your question, or Nolawi Hanak. Appreciate your question. So whenever it comes to scheduling the interview, most of the times it does take a few months for them, for all of their administrative stuff that they're doing, to schedule the interview. It can take, at least 3-4 months before you get the interview notice. Since your, immigrant visa is already available and it's been already 4 months, you might potentially wait another couple months for the interview to be scheduled. Personally, I have waited for the interview to be scheduled for someone I petitioned for 9 months, and there was immediate relative category, so the immigrant visa was immediately available, and they still waited 9 months, my parents. But here's the thing. Whenever it comes to getting that interview notice, you have to keep in mind that most likely especially since it's been already 4 months, most likely your interview is already scheduled. The only reason why you're not getting the interview notice is because by their own regulations that they implemented, they can only schedule the interview. They can only send you the notice of the scheduled interview 30 days before the actual interview date, so that you have 30 days to do the medical examination, so that the medical examination is fresh before the interview. So most likely your interview is already scheduled. What you can do, I always recommend that with situations like yours, what you can do, you can reach out to the US Embassy, your local US Embassy, where you're going to be going through the interview. Call them, say, hey, I am this and that, F4, immigrant visa is already available. I wanted to see when my interview was scheduled for. A lot of times they can't give you, they say that they cannot give you that information, but sometimes there's a cool person on the phone and they say, oh yeah, sure, let me take a look, because most likely, like I said, it is already scheduled. So for them, it's only a matter of just opening their scheduling system. It's not an official notice for you that your interview, but you will know that it's already scheduled when it is scheduled for. It's just you will have to wait until the official notice from NBC so that you can go and do your medical examination. So what you could do is you can go to the website called usembassy.gov and find your country in the list, click on it. Let's say, for example, Colombia, and you will see the U.S. Embassy, and you will have the phone number, and just call them up and, see if they give you the, when the interview was scheduled. Don't be upset if they don't, because a lot of times they don't, but it's worth a shot. Okay, let me copy this, paste this here, and we're gonna move on to the next question coming from Hayatullah Rahimi 4690. Hello, I came to the US in 1989, but I need an I-94 form for an I-765 application. How do I get it? I can't get online. It's been way too long since it. The reason I need it because I filed an I-90 application to renew my green card. Okay, so Hayatullah, in your situation, I would definitely recommend to reach out to the CBP, and I am pretty sure it is cbp.gov. Let me double check. It's Customs and Border Protection. They are the ones that can help you. Yes, there you go, US Customs and Border Protection. So these guys, you want to reach out to them, their customer phone number. Now, let me see if I can find it here. Let's see, contact. Of course, they make it always way too complicated to find their contact information. Well, it's not down here. Contact us. There you go. Let's see. Okay, there you go. So, US visitors. Or you can submit a question online. But I would recommend just giving them a call and letting them know that it's been a while since your I-94 was issued, and now you need it for your immigration purposes to apply for whatever it is that you're applying to, and that you need to obtain that record. And that's the only way to do it, because even, this online system, even for people that have not been, so long ago with their I-94 that they got, a lot of times it still doesn't work. Especially with names, foreign names. If there's one mistake in the name, that's it. The record is not coming up online. In those situations, calling CBP is the only way to obtain it, and in your situation, it's really the same thing. So let me copy this link right here, and we're gonna move on to the next question, comment from Leo and Sun Paintings 3087. Hello sir, could you tell me what is the immigration status for a person who came in under the humanitarian parole? Alrighty, I know the category is C11, but I'm not sure what to put in the status question. Thank you. Okay, Leo, thank you very much for your question. So it's exactly the same thing. It really is not that big of a deal. You can just put the humanitarian parole. If, for example, if it's like a temporary protected status, you can just put the TPS and put the country where you came from, because the humanitarian parole, temporary protected status, they are given to people based on the countries that they're from, because the country is experiencing a certain situation. So as long as you put that and then explain which country it is from, that's it. That should be understandable for an immigration officer that is reviewing your application. Okay, so let me post the answer here, and we're gonna move on to the next question from Harsh Shak 2367. Harsh Shak, thank you very much for being publicly subscribed. Really appreciate it. Is there a way to live in US and obtain a work permit just after we got documentarily qualified, but before availability of F3 visa because of the health issues of the sponsor? Is our F3 petition still valid if we are already documentary qualified and the sponsor dies? Harsha, so yes, I'm gonna start with your very last question. So yes, for the applications that have been already approved by USCIS, especially the ones that were documentarily qualified, but the main requirement is to be approved by USCIS. As long as it is already approved by USCIS, which in your case is definitely the case, yes, there is you will have to fill out additional form, and you would have to find a substitute sponsor who would be willing to be a sponsor, the substitute sponsor on the petition. But there is, you can still continue with this petition for sure. Now, regarding your question about the work permit, whenever it comes to the work permit, it is status based. So if you are in your current status that you have, if you are eligible to work in the United States, then obviously you can apply for the work permit. But for that, obviously you have to be either some kind of status that allows you to work, like for example pending asylum or granted asylum, granted refugee status, gives you an ability to work in the United States of America legally, or you have to be on a certain work visa. So if you don't have that in the moment, depending on what you have right now, if it's, let's say, just a non-immigrant status or something along those lines, and you cannot legally work in the United States, then no, based on just the fact that there is an I-130 family immigration petition pending, unfortunately that does not allow to legally work in the United States, which is unfortunate. It would be beneficial, I think, to everyone if that was the case, but unfortunately that's not the case. Okay, let me post the answer here and we're gonna move on to the next question from Avocado 5134. Avocado, thank you very much for another comment. Appreciate it. So Avocado says, thank you very much for the suggestion. I really appreciate it. Has there been any case like me who got green card and left USA due to unfinished work and came back? Where do I have to ask for the permission to stay in my country with military contract? Is it on the same day at the airport when I enter? Avocado, thank you for your question. So yes, definitely been a case. In fact, in my own family, my parents, they came here, they got all of their documents and they had to go back because they still have, the property and all the stuff that they have to deal with over there, whether they want to sell it or whatever it is they want to do. But they had to go back to finish up, all the moving stuff. So yes, as long as you are not breaking the rules of maintaining that permanent residence in United States, and it is currently 1 year, if I'm not mistaken. I would recommend doing the research, and you can find that information on uscis.gov. But I think as long as you are not leaving United States for longer than 1 year at a time, then you should be completely fine. If you are leaving the United States for longer than 1 year at a time, you would have to apply for advanced parole. I think that's what you were applying, and that's the form I-131, if I remember correctly. The refugee travel document, or just a travel document, I think that's what it's called. So if you have a permanent residence and you know that you need to leave United States for longer than 1 year, you apply for that advanced parole. Pretty sure it is advanced parole, so that when you come back, you can say, hey, advanced parole, I'm entering back into the country. I know I had to, I have good reason to. And again, you do have, in your situation, you do have a good reason why you need to be outside of the United States. And if it's not the case, if you don't need to be longer than 1 year, then you should be completely fine. You can come here for however long. It can be a couple of weeks, it can be a couple of months, and then go back there, finish up everything that you're doing. As long as you're not staying longer than a year, you stay there for, let's say, 10 months, come back here, spend some time here, then go back. It is back and forth. It is expense and inconvenience, of course, but if you are not able to resolve your situation any other way, and you want to obviously have your permanent residence here because you waited for it, and finally you will be getting it, and at the same time, not break any rules back in your country, then that's definitely the option, the route that you can take. And yes, personally know somebody who's doing it. That's my parent, and yeah, it's not gonna be any problems. And even if you do have to stay there longer than 1 year, like I said, you would just have to keep in mind, and I will find the form on here on USCIS.gov. I believe it's 131, but let me double check. There you go, application for travel document. That's what it's called. And I am pretty sure the very first option, let's see. I am a permanent resident or conditional resident of the United States, and I am applying for re-entry permit. Okay, so that's what you will be applying for. Re-entry permit, not advanced parole, re-entry permit. There it is. Okay. So what I'm gonna do is I'm gonna post the answer here. Not the answer, but the notification that I answered, and I'll put the link for the form itself. And again, this form you only need to keep in mind if you are staying outside of the United States of America with a permanent resident status for longer than 1 year. I'm pretty sure it's 1 year. It might be 6 months, but let me double check. If you file this form to request advanced parole document, depart the United States without having an advanced parole, no. To apply for re-entry permit, let me double check in instructions. Re-entry permit. Re-entry permit. A re-entry permit allows a lawful permanent resident or conditional permanent resident to apply for admission to the United States upon re-entry from abroad during the permit's validity without the need to obtain a returning resident visa from U.S. Embassy or U.S. Consulate. It doesn't say how long. But I would definitely recommend you doing the research and finding out for sure if you're planning to be outside of the United States for longer than a year. Okay, let's move on to the next question coming from My Year of Open Door Prinskel 5087. Thanks, man. I want to file for my wife and my 2 daughters in Africa to come to USA. How do I file the I-130 form for 3 of them? I'm a USA citizen anyway. Thank you very much for the question. So actually, this is the video that you commented on. This is how you do it. Currently, I am pretty sure, let me double check. I am pretty sure the I-130 is currently available to file online. So this is the best and easiest way to do it. File it online. This is the link. Again, the video that you commented on, it has the link as well, and it has step-by-step instructions. Now, if your 2 daughters are under 21 years old, then you don't have to fill out any separate petitions for them because they will be as derivative beneficiaries. So you are only petitioning for your wife and your 2 daughters. If they are under 21 unmarried, they will be automatically, added as derivative beneficiaries. Obviously, you will make sure to add your kids on the I-130, but that's really it. It's just going to be one application. If they are over 21 or if they're married, then obviously you would have to file separate petitions for them and then dealing with the backlog so far so forth. So hopefully that's not the case. But yes, this is how you do it. I'm gonna post this and I will give you the link for the form. And if you have any questions along the way filling out the form, you're more than welcome to ask them on this channel. I will be happy to answer them. Okay, moving further to James Wachira 8931. Hi, I'm from Kenya, East Africa, and my case was approved on August 2012. It's for married daughter over 21 years. When can I expect to go for interview? 2019, I got a letter from NVC, but I haven't received anything else. They told me to wait for interview. Okay, so since you are petitioning for married daughter over 21, you have to be a U.S. citizen. So that would be F3 category. Since your daughter, in Kenya right now, is going to be all chargeability area. So let's take a look at F3 on the visa bulletin, all chargeability area. We're going to look at the graph A just to see the full length of the backlog. So F3, as of right now, all chargeability area is January 2009. January 2009 is when, so January 2009 as of right now means that people with the priority date back in January 2009, as of right now, their immigrant visas are becoming available as of September 2023. This is for September. So your petition has been already approved on 2012. So I'm assuming your priority date should be, I would say, possibly 2010 maybe even 2009. I don't think it would be 2011 because it doesn't really, you don't really get approval so fast for, F3 category. So I would say you're probably 2010. But what I'm trying to say is that you really, really are close. Let's say, for example, if you're in January, let's say if your petition was accepted, your priority date is in January 2010. That means that your daughter is 1 year, judging by the visa bulletin, September 2023, the most recent visa bulletin, just 1 year away from the availability of the immigrant visa. And then obviously the interview should be scheduled somewhere right around that time. So if you want, you can come back to this channel and let me know in a separate comment. Don't respond to my comment within your comment. Let me know in a separate comment the priority date. Let me know, just to be on the safe side, let me know the priority date. Let me know the category, and let me know the chargeability area. I know the charge, but so that I don't have to remember because I'll probably forget. So 3 things, and that goes for everyone who is asking for the visa bulletin kind of estimates on how long to wait for the backlog, to go through for the priority date to become current. I need 3 things: the priority date, the chargeability area, and then the family preference category. Okay, let's move on to the next question from Stephen Bani 4143. If you have I-485 pending for approval, for renewing I-765 is free because you already paid the fees for biometric and I-765 with I-485. That's good to know, Stephen Bunny. Thank you very much for the comment. Really appreciate that. That's helpful. Unless that's a question, which I don't think that's a question, because if you have I-485 pending for approval for renewing I-765, yes, it's free. I personally don't know. I haven't dealt with both of these applications at the same time. Plus, I'm not sure why you would even bother with I-765 if you are applying for, I-485, because I-485 is the adjustment of status, and with, permanent residence, you don't need the separate employment authorization. Maybe because while it is pending, while your I-485 is pending, you're applying for I-765. That makes sense, and yeah, I guess if it's free, then it's great. Okay, well, let's move on to the next question comment from Yamelo7820. Hello, your videos are very helpful. Thank you very much, Yamelo. Appreciate your kind comment. I have a few questions. F1, okay, so first family preference category, priority date January 18th, 2018, case currently at NVC, and I'm outside of the US. 1. Once the date of filing charts moves to my priority date, I will have to upload docs and wait on the final action date to be current. Is this a current assumption? Yes, that is correct. So date of filing, graph B on the visa bulletin, shows when the NVC portal is going to be fully open for you so that you could start your documentary qualification process. So if you are not documentarily qualified yet and you're waiting and you want to know, you have the access to the portal, you have the invoice number, you have the case number, but when you log in, you cannot do anything there. If you want to know when you will be able to do something there, dates for filing, graph B, that's what you're looking at. And then, waiting for the actual immigrant visa to become available, you're looking at the graph A. And one thing I would recommend, if you are not documentarily qualified yet, I would highly recommend checking out the video on the channel I have. It's called Documentarily Qualified, What Does It Mean? And in that video, I show a real NVC portal that was documentarily qualified. You can see the forms that you need to submit, the fees that you need to pay, the documents you need to upload, so you can prepare as much as possible for your documentary qualification. Okay, number 2, as I am outside of the US and wanted to adjust my status, 2A, will NVC send my petition back to USCIS for processing if I am eligible? Send back to USCIS, and will USCIS accept an application of adjustment of status if the application is already at NVC? If I'm outside of this. Okay, so you can't apply at the same time. Let me say it this way. You can only apply for, the petition itself, the I-130 petition, and adjustment of status at the same time as an application package if you are inside of the United States. So if you're in United States, then you can send it as one application package together, the I-485 and the I-130. But if you're outside of the United States, then you cannot do that. Then you cannot apply for the adjustment status without your, getting your immigrant visa first and then coming here, and then that immigrant visa itself converts to permanent residence once you enter. It's a temporary permanent resident card that is stamp 551 stamp in your passport, but nevertheless you will be a permanent resident upon entry into the United States. So all of this adjustment of status, it happens from the outside of the United States, and you don't need to provide a separate adjustment of status application compared to if you were in the United States of America, if that makes sense. And then B, I will need to apply for advanced parole as I'm currently outside of the US. What circumstances may I cite if I'm not from Haiti, Honduras, Guatemala, or Colombia? Or may I enter on B1, B2, stay for 3 months, and then send application for adjustment of status? So I am not sure where you got the information that you can apply for the adjustment of status from outside of the United States. This is not a correct information. I would, recommend verifying that source, and always verify everything with USCIS.gov, and then the Department of State, obviously, whenever it comes to family preference categories, whenever it comes to issuance of immigrant visas, you're dealing quite a lot with the Department of State. To answer your question, yes, absolutely, you can enter on the B1, B2 while your family reunification case is in process, while you're still waiting for your priority date to become current. You can definitely do that. That's not going to be a problem. The only thing you need to keep in mind is, I wouldn't say in most of the situations or half and half, but a lot of times it's a little bit complicated to get a non-immigrant visa to enter the United States while you have an immigration petition pending. And that makes sense, obviously, because you are going and asking for a non-immigrant visa to visit the United States, and then they look in the system and then they see that, well, you're actually planning to immigrate to the United States eventually, and that might cause a problem. Sometimes you look at it and say, well, yeah, of course, we understand you want to go and visit your family and travel back and forth, have the ability to travel back and forth, so they grant the non-immigrant visa. But in some situations they deny it just because you have the immigration petition. So keep that in mind, just in case, don't be upset if it is denied. So let me post the answer here, and gonna finish up on this one today. Let me know if you have any follow-up questions, any follow-up comments. I will be happy to answer them. Just make sure that it goes for everyone. If you have follow-up comments or questions, make sure not to ask them underneath my comment. Don't respond underneath my comment in your comment, because YouTube does not send me those notifications. So thank you very much for watching. As always, appreciate it. God bless you all, and I'll see you in the next video.